Welcome back, everyone, to our studies in the law of criminal evidence. We're continuing talking in this lesson about topic number 3. Now, topic number 3 concerns witnesses. Now, specifically, we're going to be exploring a couple of different key areas of examination. The first of which we'll talk about the idea of witness competence, so what it means to be a competent witness in the course of a trial, and think about how the law approaches that issue. We will also think about how that issue is approached with reference to people who, where the witness competence might be questioned. So, for example, as it relates to very young children. And we'll also talk about the distinction between witness competence and witness compellability. The fact that the courts in certain circumstances are able to compel an individual, a witness, to testify at trial. This lesson specifically is going to examine the general test which is associated with the competence of a witness as it relates to a criminal trial. Now, the majority of the regulation that we can see here that is found in statute, at the very least, is found in the Youth Justice and Criminal Evidence Act, a piece of legislation from 1999. Now, specifically, there is also case law that we're going to explore as well that illustrates the difficulties in some circumstances in making determinations as to what makes a witness competent and the circumstances in which competence might be presumed. So the general rule for thinking about competence is that there is a presumption of competence. There is a presumption that a witness in question is competent to give testimony, and it is really up to either the parties to the case or to the courts themselves to determine whether or not this presumption may or may not be rebutted, whether or not it is the case that the individual in question is in fact not competent to provide evidence. And this generally means that an individual, regardless of their age, will be presumed competent for the standard of a witness. And we can see this in section 53(1) of the Youth Justice and Criminal Evidence Act, where it says that, quote, at every stage in criminal proceedings, all persons are competent to give evidence. This here encapsulates the presumption of competence. It encapsulates the view that all persons are competent to give evidence at any stage within the criminal proceedings. And then from here, we then go to how this assumption, how this presumption can be rebutted. And we can see in section 53(3) that a person is not competent to give evidence in criminal proceedings if it appears to the court that he is not a person who is able to either understand questions put to him as a witness and give answers to them which can be understood. So this is what would be the test for determining whether or not an individual is or is not competent to give evidence in trial. They are considered to be not competent if they cannot understand the questions that are being put to them by defense counsel or by the prosecution, and they are unable to give answers which can be understood by defense counsel or the prosecution either. And so ultimately the rationale for the general rule here is that evidence should be brought to the contrary regarding the competence of a witness. So rather than spending quite an arduous amount of time and effort and process trying to sort of go through the sort of civil or sort of the criminal litigation procedure of dealing with every single witness and trying to show that the witness is in fact competent, we just assume, there is just an assumption and a presumption that everybody is competent, and if and when an individual who is deemed not to be competent does get called forward or is called to give testimony, it is at that point that one of the parties involved in the trial is able to raise a question as to this point, is to raise a question as to whether or not they would satisfy the requirements in the test as found in section 53(3) of the Youth Justice and Criminal Evidence Act. If no such contrary evidence is therefore presented, then they are presumed to be a competent witness. Now, this is really interesting when we think about children and cases that involve children. We're going to spend a whole lesson in the next video talking about witness competence as it relates to children and child witnesses. But in this video, I just want to touch on it very briefly. The idea that essentially, when we think about competence of witnesses and when we think about challenges to competence of witnesses, we are often doing so from the perspective of children. So there might be some circumstances where people who might have certain learning difficulties might have challenges as relating to their competence to give evidence. But for the most part, when thinking about competence of witnesses, it is a question that often involves children. It's often the case that a child is the question is raised about whether or not they are competent to give evidence. And the case of Crown and Powell is one such illustration of this point. This was a case in which the individual in question was 3 years old when the alleged offence had taken place. They were, it was essentially the allegation of an assault, and an assault had taken place. At trial, they were only 4 years old, so they didn't got much older by the time trial rolls around. And so the question here is whether or not the individual in question, who was only 3 years old, could be competent to give evidence. The courts held, and they spent a little bit of time actually examining the nature of competence in relation to the age of a victim. And they say here that Section 53 of the Youth Justice and Criminal Evidence Act makes clear that the age of a witness does not determine whether he or she is competent to give evidence. And this really is just the full encapsulation of what we mean by the age factor. So age is not a consideration for whether or not somebody is or isn't competent. It's not like if you go below a certain age, everybody under that age is automatically not competent to give evidence. But equally, there might be some higher considerations the younger and younger somebody gets as to whether or not that person is competent or not. And so the circumstance means that when it comes to people of a particularly young age, their competence isn't defined by their age, but it is instead their ability to communicate and to understand questions put to them. So if somebody is 2 years old, for example, or 3 years old, as was the case in Crown and Powell, the question of whether or not they are competent as a witness is not a question about whether or not they are old enough to give evidence. So a 2-year-old theoretically, or a 3-year-old could theoretically give evidence in trial and be a competent witness. The question is not their age, though. It is whether or not they can communicate and can understand questions put to them. Now, if you're anybody that has children or has dealt with children, you will know that the younger you get, the less likely they are able to communicate and understand questions. The age of 3, there's probably some debate there. There are some people who are 3 years old who can communicate very well and can understand questions probably. But then the age of 2, probably maybe a little bit less. Age of 1, definitely not. And so the question isn't their age. The question is just the fact that their age is often correlated to their ability to communicate and to understand questions. And it means that the courts have established, being able to understand the questions put to them is also something about, it's something a little bit more specific than understanding whether or not they are a witness. So when we say understanding questions that are put to them, we mean that essentially in a vacuum. We mean that absent any other factor. So long as a child, or so long as somebody whose competence may be questioned, maybe someone with learning difficulties, as long as they can understand a question, can understand what the question is, and can communicate back an answer to that question, then they are deemed to be competent. Now, they don't have to understand what a criminal trial is, or what the common law adversarial system refers to, or what a witness is to a trial. They just have to know how to answer the questions that are put to them. And so they don't have to have this broader contextual knowledge of what is taking place, but only the knowledge of how they can answer the questions that are put towards them. Which means that when we focus on competence, we're focusing on a very specific point. We're focusing on a very specific illustration. With all this in mind then, and all this being said, how do we question competence? Let's say that we have a trial and there is somebody who may or may not be able to answer questions put to them. They may not be able to question or be able to essentially meet the test of competence as per the Youth Justice and Criminal Evidence Act. Well, since competence is presumed for all parties, since it is an assumption that everybody is competent at all times throughout the trial, it is either up to the parties involved in the case or the court to raise questions as to the competence of a particular witness. Once a question of competence has been raised, it is then up to the parties calling the witness to satisfy a test for whether or not they're competent. So essentially, a challenge of competence has taken place. It is now up to the party that is calling the witness to essentially show that this witness is in fact competent. And the standard by which they do so is a standard of on balance of probabilities. It's the civil law standard. And so, in other words, on balance of probabilities, given a balance of probabilities, can the witness in question understand the questions that are put to them, and can they give answers that can be understood? That's essentially what is done in terms of the test. We'll explore children and the relationship between competence and witnesses and children in more detail in the next lesson, because there are some further considerations that we can add to this conversation that we haven't yet fully explored.